Good afternoon, everybody. Thanks for joining us today. We've had a very large response to this event. So a second, turn your thing off. That's it. Thank you. That's it. Getting an echo. Yeah. So we've had a very large response to this event. This was originally kind of designed for our clients and people who knew us, but it's gone out to a sort of wider audience now. So there's a few of you on this call who do know who I am, but a few don't. So I thought I'd just quickly just sort of run through who I am. So my name is Paul Stephen. I'm the CEO of Sagittarius. I'm going to put my details up here. I'll put them up again at the end, really. But if anything out of today's webinar, you have any questions or want to ask me anything, then please do get in touch. We're trying to cover a lot of ground today, so it won't surprise me if we end up with a few questions. Just quickly, really, this is not really a pitch, but Sagittarius is largely a data-driven agency. We have sort of two sides of the business, which is the sort of marketing side of the business, and then we have the website design and build side of the business. In terms of the sort of things that we're doing here, we're doing SEO and paid search and social and content, etc. And then on the other side, we're obviously building websites, mobile apps, looking at user experience, and generally part of a larger digital transformation piece of work. And you've got things like then CRO and remarketing and stuff that possibly sits in the middle of those two sides of the screen. So that really kind of puts in context why GDPR is really important to us as an agency and to the clients that we work with and the work we do with them. So the title of this GDPR seminar was kind of deliberate, really, because there's a lot of, well, increasingly anyway, a lot of talk and a lot of webinars like this, events like this, all sorts of services being offered by various people about GDPR. Yet I'm starting to see only now brands and people start to wake up to it, and for a lot of customers of ours, I feel like they're like our friend here from the IT crowd, where they know it's going on, but they're just looking at it and pretending it's not really there and carrying on regardless. And that really worries me, because it is actually a big deal and people are not doing anything about it. You know, it's something that's developed over time, or the reason for GDPR is now, if you like, a manifestation of what's happened since the beginning of the internet. This is Tim Berners-Lee, for those that don't recognize him, the inventor of the World Wide Web, allegedly, well, actually. And he sort of said, you know, the web was there really to create a level playing field, to open up, so, you know, it's accessible to anybody and anybody can do anything, etc. But of course, along the way, that sort of freedom has resulted in us actually sort of more or less losing, as people anyway, control of our data. So I just wanted to talk a little bit about this. This is actually the European Court of Human Rights here, and the thing to sort of try and get your head around with this is this EU GDPR regulation is really born from a matter of human rights, really. This is, as I'll go on to explain, really about you as a person and your human rights and what people can or can't do with your data. It's your data, it's not their data, it's information about you and how they treat you. So it's really coming back to human rights rather than, if you like, the law of the European Union. Notice this is the European Court of Human Rights, not part of the European Union as such, or this thing that we're trying to exit as such. So that's, I just thought I'd make that point, really. I thought it was a nice way to start. So GDPR, what is it? I did say I was going to try and make this presentation as interesting as I can, but this is one of the few slides I've got which is quoting bits from it. But really, GDPR, firstly, what does it stand for? It's General Data Protection Regulation. See, some people call it General Data Privacy Regulation. I've seen it called other things as well, but that's actually what it is, General Data Protection Regulation. And it does actually replace a directive that was goes back to sort of 95. It also replaces a bunch of other things as well. I'm trying to do as little of these type of slides as possible, but just to give you a little bit of history. So there's been various data protection directives and acts along the way over the years, and this is actually a kind of an evolution of it, really. The last one, the Privacy Directive in 2012, was the one where everyone got very excited about the cookie law and things like that. That was kind of when that happened. So this general data privacy regulation was actually, as they call it, enacted in April and then in force in May 2016. So that's now, you know, a year and a half ago, really. But it actually comes into force on the 25th of May next year. So as opposed to the other stuff, why is this one particularly different to any other sort of stuff that's listed before? Well, it makes it clear that it's the data subject. I'm going to talk about data subject in a moment, but it makes it clear that the data subject owns any data which describes or identifies them. The other stuff is about what the brand should do or what you can and can't do with data. This is one is really sort of making clear that it's the data subject who's in control. And they have the right to determine how it is used, check it, withdraw it, do whatever. It's their data. And then the other thing that's important is that anybody who handles that data is now really kind of accountable to it. And that is also more powerful now, because it's not just the person who's controlling the data as the data controller, but it may be the processor, so the software or the people who are providing the software that you're using that data within. So it makes those sorts of things clearer. Essentially, though, as I said, it kind of in many ways is an evolution of other laws and regulations and acts that have gone before. So actually, some of the principles aren't chalk and cheese. They're possibly just a little bit more explicit than they were before. It does introduce, and some people have got quite excited about this idea, there's some big fines possible if you're seen to be contravening any of these sort of the regulation. And it is big because it's actually up to 4% of your global turnover. So if you're a huge brand and you're contravening this stuff, then that's a really, really big deal. Well, a big deal for a small company as well. But you can imagine the numbers are, and there are no ceilings on these numbers. It's actually quite considerable. As I say, there's the difference around risk, and in that now it's the person who's not only controlling the data but also processing that data that could be held accountable. The rules around liability are pretty much saying that, well, look, you're all responsible for it, really. Ultimately, it may be one of yours fault when it goes to court, but the start position is you're all responsible. So therefore, people like Facebook and Google should care what you're doing with their data, because in a way, doing with the data, because in a way you're using their system to do it with. Whereas at the moment they could say, well, it's not our fault. So then just emphasizing that point. So GDPR is about protecting individuals, really, their personal data. It's not about company data, it's about people and the free movement of that data. So just to clarify a couple of things on the language they use the words data subjects, which are natural persons, people to you or I. And they refer to personal data, and that's data referring to that data subject. Now, an important thing to get your head around is what that means is it's about the data subject people, and those people that are EU citizens. So it's not where the brand lives, it's not what software you're using. The point is, it doesn't matter if you're an American brand and you're using an American piece of software. If the data in that database is for an EU citizen, then you've got to be compliant with GDPR, because it's the person whose rights are being protected here. The last bullet point on our put is about being future-proofed. Well, I'd argue it could never be fully future-proof, but they've tried to not make some of the things too specific or explicit, so therefore it's got a little bit of future in it. You can broadly describe certain types of use of data. Of course, by being more broad, it potentially makes it a little bit ambiguous in some areas, which some people could consider advantageous, because that puts a little bit of flex into what's being described. So what it's not, what is it not? So this, in terms of data protection, there's all sorts of things around. People don't like the idea of people be snooping on their data, etc. So it's nothing to do with that. It's not sort of Big Brother. It's not about changes in infrastructure per se. GDPR actually isn't really talking about security as such. There's plenty of other laws and other things you should be doing to protect security. But of course, GDPR is covering things like what to do in the event of a data breach. So therefore, it implies you need to toughen up on your security infrastructure, but the GDPR isn't necessarily covering that subject that explicitly. In fact, not everything is covered that explicitly. The trouble is, what you need to do to comply is going to be different for your business, within your market sector, all sorts of factors. So GDPR isn't going to tell you everything that you need to do explicitly. It's giving you guidelines of what you should and shouldn't be doing, and actually how you interpret that and behave in a way that complies is going to be down to you. The other thing it's not, and because of that, at the moment they're not able to tell you exactly what you need to do. So at the moment, agencies, brands, and all the lawyers alike are interpreting those regulations and saying, well, in that case, I think we need to do this on our website, or we need to do that. And you're getting guidance from ICO as well, Information Commission's Office in the UK. But actually, that's everybody's interpretation. So therefore, it's not really tested yet. It's yet to be tested that after 25th of May next year, that a brand is pulled up for contravening or not complying based on what they've done, because they could argue, well, it does comply because we did X, Y, Z. So it's not really tested yet. So there's a few caveats like that in everything I'm going to say today. So, and then just covering off, what about Brexit? Well, at the moment, I wish I knew what was happening when Brexit finally comes. But at the moment, we're pretty certain that it's going to be happening after the 25th of May next year. So therefore, between 25th of May next year and whenever Brexit happens, we're definitely in on this. Everything that's in this regulation applies to us. We have to comply. And as with every other law we've got in this country, the reality is we'll probably be having to do our version or copy it anyway. So the fact that Brexit is on the horizon, shall we say, is almost irrelevant. You can't say, oh well, Brexit's coming, this won't apply to us, because I think it certainly will. That's my standpoint anyway. So I mentioned a minute ago, but really, so the key guidance for a UK company, as well, assuming most of you on the call in the UK, is the Information Commissioner's Office. They are the ones who really are tasked with, they were tasked, as I'm just going to talk about, with helping shape what the regulation was as part of the EU. But now they're the ones meant to be providing the guidance to you as a business. If you search for ICO GDPR, you'll find they've got loads of content there, loads of good content, and it's where some of the docs I'm going to mention today, you'll find them to download as well. So really, the sort of proper authority in the UK is the Information Commissioner's Office. So one of the things that I'll talk about it a bit more, but one thing you all should be doing as a brand or as an agency or whoever you are, should be registered already with the ICO as a registered data controller. Costs £35 to do, or something like that, if I remember rightly. It's not a big deal, but you should definitely already be there anyway. So I mentioned it in the brief for this event, but Sagittarius, or myself and Sagittarius, were lucky enough to be invited to be part of this panel. So over the 2 years that the GDPR wording was being debated and circulated around the EU, the Advertising Association formed this data governance forum, which consisted of, as you can see, a lot of either large brands or considerable trade bodies. And I actually represented BEMA down on the bottom right there, which is the British Interactive Media Association. So we were being given versions of the wording of the GDPR. We were then being asked to go and read it. It was a lovely 300-page read. We'd go through it, and then we would sort of flag our issues or things that we thought we'd like to see changed, or we didn't like the sound of, and that was kind of then fed back through this forum to the ICO, and then obviously that then was fed back to EU with all the other countries involved. And So that was the process, and that's why, even though I'm no lawyer, I kind of have been around GDPR for now probably nearly 2 years. I didn't join it at the beginning of that forum, but I joined sort of halfway through. So the GDPR itself is a very long document. One could argue there's no escaping that really. To learn everything that's in it, you should go and read it. But for most people, and that was why I put this presentation together, I was trying to create a presentation which didn't where you didn't glaze over by the time you got to the 10 minutes in. So hopefully I'm going to try and bring some of the key elements to life. The ICO actually have produced this this screen. It's actually a document, but about the 12 things you should be worrying about now, as a brief summary. I'm actually going to just focus on these items that I've highlighted here during this call, because there's just so much to cover. There's things like item 8 there about how you deal with children, which is a complicated issue in its own right. We could probably do a whole webinar just on that. So I'm not going to focus on everything that they say in the 12 here. The things I thought that would be the most relevant and timely, and things I could get through in a webinar. So the first one I'm going to talk about is legitimate interest. So what GDPR is trying to do is say, well, as a business, you shouldn't be either holding data or processing data. They call it processing, which sounds like a lawyer, but basically you're going to do something with it. You're going to use it to do an emailer, or you're going to use it to personalize something for somebody. So that's all processing. So what is your legitimate interest? And they pretty much summarize it down to 6 grounds of lawfulness. These are reasons why you have a legitimate right to process someone's data. So I'm going to whip through those quickly. So you need to use that data. So consent for specific purposes. So you've asked them, they've said you can use it, and you need that to deliver whatever it is you're doing with them. So that's kind of obvious, really. Controller's legitimate interest. So therefore, if I'm an organization and I have to keep your data to prove that I worked with you, I sold something to you, or whatever, then that's a legitimate reason why I need to hold that data and keep it and do things with it. That may also then be tied to a contract, for example, maybe overlapping with the previous one. So I don't know, for example, if you're a travel brand, if a person has traveled with your tour operator, then you need to keep that data for so many years to comply with the contract you have with ABTA and your insurance and things like that. So there are always reasons why you might need to hold on to that data. Yeah, and that may actually even be a legal obligation as well in some instances. Things like telecommunications companies are legally obliged to do certain things with data. It may be that actually that data you have is your proposition, is your vital interest. So you couldn't delete it, otherwise you don't have a business left, for example. And yeah, maybe overlapping with some of the others here, some sort of public interest or official duty. So those are the things that they say mean that you can lawfully deal with the data. But the one at the top there, consent for specific purposes, is again quite ambiguous. That means I could apply that to all sorts of things. So there's still open to, some of these are still open to interpretation, I would argue, which is possibly a good thing. So of those 6 grounds, consent was one of them, and therefore it brings up the subject of consent. So this consent, they use the word, it should be given freely, it needs to be specific, they need to be informed and explicit. It can't be woolly, it can't be vague. So let's just, I've tried to do as little of this as possible, but this is a sort of quoting one of the lines from the regulation, but it says, in a manner which is clearly distinguishable from the other matters, in an intelligible and easily accessible form, using clear and plain language. So that's their way of saying it. I'm trying to make it a bit shorter. So when assessing whether the consent is freely given, they're saying it should be it's whether it's in for the performance of a contract, is conditional on consent to the processing of personal data that is not necessary for the performance of the contract. So basically, it's their long way of saying that this is where the conditions are coming from. One of the important questions that comes up is, well, okay, that's with new stuff, new data capture, new data that I've got, but how do I deal with the stuff I've already got? So again, this is my interpretation and interpretation of others, and others are debating this as we speak, I'm sure, is that in theory, if you've captured that data already and you captured it in a way that was pursuant to Directive 9446/EC, then in theory, if you captured it in that way, you said why you were capturing, you said what you were going to do with it, and that's all you're still doing with it, then one could argue you don't need to ask their consent again. If, however, you captured it in a way previously where you just asked them to sign up your newsletter and now you're going to do different stuff with it, then absolutely you should be re-asking for their consent. So I don't think that is unambiguous. I think that kind of makes sense. And that's my understanding and interpretation of it. Now, another area in consent that is now talked about quite a lot, and it's actually one of the big things that's a very sort of actionable item, is unbundling that consent. So the advice is it needs to be explicit and it needs to be transparent. So the idea is, rather than just saying, yes, I've got permission to talk to you via email, it's more, well, how can you can talk to me by email, but only about this, but not this, and you can only do it this often or whatever. So again, there's some guidance from the Information Commissioner's Office, but in terms of exactly what you would do on your website, that is kind of down to you to interpret and change it accordingly. So all we've got to go on at the moment is maybe some examples of people who are perhaps doing it right or considered to be doing it right, and then for us to go away and make our own decision. There is no real kind of one-size-fits-all solution to this. So I've pulled together some examples which I think might help you get your head around this. So, for example, this is a sign-up form on the Sainsbury's website. They've here clearly separated that, yes, you approve to our terms and conditions as one tick box, and then they're asking you about your contact in just a yes or no option there. But they've bundled all the different ways they're going to talk to you about money off, coupons, offers, etc., all in one thing. So not that unbundled, but at least they're separating, accepting their terms and conditions and contacts separate. Fairly normal stuff. Take this one. This is Age UK, one example on Age UK, where they've taken the trouble to give you the option to be contacted in different ways, not the subject about what they're going to talk about, but how they contact with you. So that's another way of making it more granular. Then I've got this example on Waitrose, for example, where yes, you can contact them, but when they're talking about third parties, they're now giving, within the Waitrose John Lewis partnership, they've got Waitrose, they've got John Lewis, and they've got their financial services. So here it's you have the option to not just sign up to everything, you get to then break that down a little further, which I think is interesting as well. So those are the sort of things we all need to be looking at. The next area, obviously, that goes hand in hand with that is, well, when you're getting them to sign up, what are they signing up to? We've got to be transparent. We've got to tell them everything we're doing. Well, that's usually the stuff that's buried away in the privacy notice that none of us read and we just click OK. But they're arguing, saying, well, that's not enough anymore. Burying it in a long T's and C's page isn't really acceptable anymore. So in terms of what needs to be in there, they're saying being transparent, often honest. So the interpretation is you need to tell them what you're collecting, who it is who's actually getting that information. Is it me, or is it me and a third party? Who's actually collecting it? How are we doing this? Why are we doing it? What we're going to do with it? Who potentially we're going to share it with? What would be your process now for saying, can I have that data back, please? Can you delete me, etc. So all this needs to be in there, and so all these things need to be in there, but bearing in mind the T's and C's page is just not acceptable. So the ICO's way of kind of trying to explain how you should be doing this is you should be doing this is a screen grab from their recommendations of how you might say do some of the screens I've just shown you. They as you can see, they give you a very sort of idea of how you might do it. So that's just the way the ICO are explaining it anyway. They're also suggesting that, well, okay, you might need to add another layer. So at this layer, how will we use the information about you? They've given a short description of how you might what you're going to do with the data, with a link off to a more detailed explanation of that. And that's quite an interesting route. Rather than just saying, click here to see the terms and conditions, you're actually kind of giving someone a bit of a preview and then giving them the further information. This is an example here of, the idea is, in theory, you could start using inline hints and tips, etc., along the form, so someone isn't having to go off to another page, or every little field you're telling them why you're collecting it and what you're going to do with it. An interesting idea. Equally, here's another example, again, just helping to explain as you go along the way. You want to reduce the friction. The trouble is, the more information we give people, and potentially most of us from a marketing point of view would be worried about, oh, that's another barrier, that's going to reduce conversions, etc. So this is pretty much a user experience challenge, is, well, how do we give them this information? How do we give them this transparency without effectively switching them off completely? So it's quite a challenge. Right, so the next subject I want to discuss was the right to erasure. Now, this is a huge subject and is possibly one of the most sort of scary, is that sometimes called the right to be forgotten clause. But basically it's saying people now have the ability to come to you and say, well, you've got my data. I don't want you to have that data. I want you to remove, for a long time, people have, if you like, had you've been obliged to remove somebody from a database, or rather unsubscribe them from talking to them, etc. But this is going a step further than that. This is, yes, they can come to you and say, look, I don't want you to send me stuff anymore. You don't have my consent to do that, even if I gave it to you previously. But now they have the ability to say, I want you to remove me from your database. They also have the ability to say, no, I don't want you to just delete me. I actually want you to give me that data, and I want you to give me that data about me and everything you know about me in a format that I can give to someone else. Now that's huge, because quite frankly, barely anyone in there, either in the system they bought themselves or most of the systems they're buying off the shelf, have really got a button where they can easily go, hey, take this person and delete them from my database or anonymize them in my database. This is a big deal, and it's something that we're obviously wrestling with various clients of ours in how best to do that. And when it comes to deleting as well, it's kind of, well, what do you mean delete? This could be major issue. So we're being asked to delete their personal identity, because that's what really they own. But so you've got to then, well, where is that data? It's not just in your website, potentially, it's in your CRM, it's in your whatever other bits of software you might use. It might be in marketing mailing lists. It's potentially, and we've got some brands we're working with where we've found it in 32 different systems. The ecosystems for people's data is sometimes massive. Potentially this now, well, it includes the backups. So if you've got backups of customer databases and they've asked you to remove them, then in theory you should be deleting them from the backups. But then the point of the backup is that that's there to protect you, so you can wind it back to a point in time. So that's a challenge. This includes third parties. So for example, if you're buying a service, or someone's bought a service from you, they're in your database, but then you're putting that data in somebody else's system in order to fulfill whatever it is that you're doing, then you should be deleting them out of that third party as well. So have you got systems and processes in place where you can actually act on this request? Yeah, so this is more of that. So, for example, if you've got databases and lists of people and you're putting them into Facebook so you can do retargeting or whatever, those are all places that you're putting that data, which you've got have the ability to go and remove that person from your ecosystem. Next thing I'm going to discuss is data breach notification. So basically now you're obliged, if somebody has got hold of some of your data, you are obliged to do something about it. So that means it doesn't mean that it doesn't mean that it's been hacked or whatever. It just means that data's got into the hands of somebody that it shouldn't have done, and that may even be an internal thing if that would be considered as a breach. So now you've got 72 hours to tell the people who've had their data or their data has been leaked. Plus, you've also got authorities to advise. So you, in the UK anyway, should be advising the ICO that you've had a data breach. That's why I'm saying you have to be registered with them. There's all sorts of, depending on where you are in the world, or maybe what even sector you're in, you have to work out, well, who you should be advising over and above the people whose data has been hacked. I mean, and the point there, breaches occur, no 100% secure systems. You can pretty much guarantee something's going to happen. If you were going to naively think that every system is 100% secure, then that's a little naive. So you kind of have to take this as read. Well, basically, this is likely to happen at some point, maybe in a small way, but it's likely to happen. So what we're going to do about it? So it's not something you can just park for a while. You need to sort of assign somebody to this who's going to actually supervise it and enforce it and make sure on an ongoing basis we've put ourselves in a position so we don't get a data breach, but somebody who's going to say, no, that data has been breached, who's going to follow up and find out what happened, how it happened, tell whoever they need to know that the breach happened. So this is something that there needs to be a bit of a plan, because you've only got 72 hours to respond to this. If you haven't got a plan, then that is not a very long time at all. You haven't also got to tell them, you've got to tell them what happened. So you've got to be able to have some tools, etc., in place to be able to diagnose what happened during that breach. What did they get hold of or take away, etc. In terms of data breaches, there's advice around trying to make that as secure as possible. So, for example, encrypting data when it's at rest. So if you've got databases and they're not active, make sure they're encrypted. Therefore, if somebody did actually get hold of that data, they kind of got something that's encrypted and they can't actually even open it. So those are all things that are reducing the amount of damage that could be done by some sort of data breach. That's kind of security, you could argue, but it goes hand in hand with this, because now you are very much responsible. The next subject I just wanted to cover was automated profiling. So the way the wording is worded in GDPR, sorry, is individuals have the right not to be subject to a decision when it is based on automated processing and it produces a legal effect or similarly significant effect on the individual. So what they're saying is you can't sort of take data that you've got about me, change the way you deal with me without telling me that's what you're going to do. So this is kind of quite alarming for people in marketing who are starting to think, well, hang about, we're trying to do stuff with personalization or do stuff to improve conversion rate optimization, and I might need to tell them I'm doing that now. So that's the first part, and the next part is they need to be aware that they can, someone can intervene and change that. So no, I don't want you to profile me. I want you to treat me like your default user. I just want to get the same as everybody else. So this is an area which, again, this is a whole subject we could do a whole hour on this probably as well. But it's the area particularly that interested me as a marketer. The sort of reason for it originally, or kind of the wording as it is what as I've explained here, is it's about, well, you can't automatically do stuff with me where you're monitoring my performance at work or my economic situation or my health or my personal preferences. These are all things that you can use, but you've got to tell me that you're using them. So what I've not seen any great examples, it's one of the things we're working on at the moment, is, well, how do we nicely tell people that we are optimizing the website based on what we know about them? Now, for some time with the cookie law, we were saying, well, let's have your cookie, or let's use cookies, and therefore we can do stuff that makes your website experience better. Well, now we're having to kind of go a little bit further and say, well, look, let us use cookies, use your IP address, and we're going to watch everything you do on the website, and the result of that means we're going to do X, Y, Z. And this is, again, open to interpretation, but if you look at the criteria they've put there, there's personal preferences, there's their behavior, and then there's movements. So the sort of things we talk about a lot, like what they've done on the website, where they are in the world, are they using their mobile or are they on the move? Those are all things that, to me anyway, fit into those criteria. So bit of a worry, to say the least. But there, it doesn't mean everything like that. Personalization and remarketing is dead in the water, but far from it. But there's some things that we can't do anymore, and there's some things that we can. But from a marketeer's point of view, one could argue, and this is one of the conversations we have a lot of time, this GDPR is really creating an opportunity for marketers, really, and from my point of view is something I'm quite excited about and want to kind of embrace it, really, because it's a fantastic opportunity to get data in order. You know, we work with obviously lots of brands which will remain nameless, or maybe even ourselves. We all have got data in lots of places. They've, you know, it's just organically over the years we've ended up with different systems, and we connect one system to another system, and then we abandon the system, and it just sits there. And that's typical behaviour. I'm not trying to cast any aspersions on our brands or ourselves, but it's just kind of the process we've been going through. But this is the opportunity to clean house, tidy things up, get things in order. So some of that is going to take time, some of that is going to take money. And the thing is, from a marketing point of view, if you're a marketing person and you want to, or an operations person or the board, you of course want the best customer user experience. Well, this actually does create the business case for that. It's okay, we need to do it for GDPR reasons because we need to tighten up on our data and we need to prepare for certain things. But ultimately, it's going to give us lots of these exciting, it's going to build the business case and the financial case for doing this work. Again, it's going to improve data security. There's very few brands that could do with improving that even further. It possibly is the catalyst for the sort of digital transformation that a business might need. It's the thing that might push it over the edge from holding back and not wanting to change. It legitimizes the reason for doing that. For me, the opportunity is about really, well, if you're going to get under the skin and let people opt in to what they really want to, if you're going to get closer to those clients, then you're really starting to learn what your clients really want, don't want. So improving that sort of empathy. From their side, obviously, that should improve customer experience. And you know, you need to worry about, well, what's the give, get, exchange? What if they're going to give you that information, give you permission to do whatever you want to do with it? What's in it for them? And really, by doing that is an opportunity for us to really build trust. And I think, you know, the problem with data is some brands have abused that privilege, and they spam people, they advertise to people in a way that annoys them. So that's why people now are saying, well, look, I don't want you to have the freedom to do that. I want to choose. So if your brand is happy to have that open conversation, then your reputation with them and trust will build. And for me, that then is the opportunity for you to be the one that does do that, whereas the other guys don't do it. So therefore, you have a competitive advantage. So I think the idea of getting your data in order, embracing GDPR, and using all the tools that they say you should do is going to improve your customer experience and relationship. And that should be a business winner. So rather than just face it, as our friend here was doing, and not do anything about it, I think we just have to accept it's a big deal, and we should get over it and get on with it. Quite frankly, it affects our whole universe. GDPR is coming. You're not going to stop it. You can't sort of turn a blind eye to it. It's coming to us as a brand, but that then also is coming to audiences. You know, the public hasn't necessarily woken up as much as we have to this, so who knows what they might come up with and how they might embrace it when it gets here. It really affects our whole universe in terms of all the partners that we work with as well. And yeah, it is serious, it is complex, and there's a load of stuff that none of us know yet. So I'd love to sort of sugarcoat that a little bit more, but that is where we are. So one of the ways I wanted to illustrate this, I thought it was a good way of illustrating how at the moment we've got a brand, we've got the audiences, and we've got our partners. And at the moment, an audience, our users, for example, give us data all the time, and that's worth something to us. And then in theory, we're giving something back to them. That's the kind of give, get, exchange. Equally though, as a brand, we're probably working with other partners, and we've got data that we're capturing that is kind of has a value to the partners that we work with in some instances, and they give us something back. But this whole relationship is now in danger, and at the moment it relies on trust, because that data there if we don't have the trust, it just disappears. It can't exchange. So it's really important from our point of view. It's really important from the audience's point of view that we all know what we're up to, and the trust remains. And if we can get the trust right, and they know what we're doing, then all those things are still okay. The other thing just to emphasize is, for this to actually work, this isn't a marketing person's problem. This isn't just a technology problem. This involves everybody. So it doesn't matter who you are in your business or where you work in the business. Together, we need everybody in the business to really understand how big a deal this is. And then we've got to take all of them on a bit of a journey. And that may start with some sort of audit to really understand where they are right now. And they've got to go on a whole journey to a point that they are compliant. The other thing is it doesn't just include us in our company and all the important people. It includes everybody we work with, all our partners. So for brand or agencies alike, you've got all sorts of media partners, people who are doing vendors who we buy stuff from, the agencies you work with if you're a part, if you're a brand. So there's so many different people that need to really get their heads around this. Otherwise, we can't trust each other, because the promise we're delivering as a brand is also the promise that our partners are delivering. And then to take it a step further, what we might be doing where we are in the world, in the UK or wherever we are, we need to worry about, well, what's the trust we need to have locally, regionally, or perhaps globally? So depending on the size of your organization, the type of work that you do, that's huge. I mean, travel companies we do a lot of work in the travel space, and that's if you consider travel by default is probably operating in more parts of the world as a sector, is by default happening in other places in the world. So all the places that a customer's data might live, when you're a travel company, especially when you're engaging third parties to do your flight or your accommodation or your car or whatever it might be, is huge. So you need to have trust in the partners that they're operating in a way that is going to help you comply. So in terms of the different systems, that means, just for ourselves, if we say, you've got also, you haven't just got your website. This is any of the sort of marketing apps that you use, your CRM or ERPs. There's all sorts of places where this is going to have an impact. Most people are thinking about it from a web and digital point of view, but really it's an operational tool as well. So it's absolutely necessary. It's fundamental to the operation of your business, and it's going to have to require investment. There's no way of doing it. You're going to have to assess where you are now, plan where you need to be, and comply, and then you're going to have to keep complying. There's no way of sugarcoating it any better than that. So one of the things that the GDPR kind of talks about is privacy by design. So this is, well, really this requires a fundamental change in the approach that you do things. Now here at Sagittarius, we've been for a long time, when we design things, looking at how can we do it so it's the best customer experience. It's kind of what we win awards for. We're also looking at, well, how we're going to use that data to enhance that experience. So it kind of isn't much of a change for us, but it just adds another layer, really. So they're just suggesting, really, from initial idea through to costing it, to building it, to uploading it, there's a whole process now that might really take more time to do it properly. So there's a cost associated with that. We're certainly here at Sagittarius, we're having to introduce new processes, which means things are going to take longer. But if we don't do that, then ultimately on the other side, if we don't do that, then risk is what we're trying to avoid. And we don't want risk. What we want is trust. So one of the things that you can do as a takeaway, this is another thing that's on the ICO website, so another reason to go there. By the way, I think we'll send an email around at the end after this email for everybody who's registered and joined up to links to these things that I'm talking about. So they have a thing called a privacy impact assessment. I'm seeing it referred to as a PIA quite a bit now. But this isn't really a document, but it's a code of practice. It's a process you should be going through when you're building anything and looking at your workflows, really. So this is the sort of thing that we're now having to introduce into any new website builds, any new significant upgrade to a website where certainly where anything to do with data capture is involved. So this is not just about the website, and it's not just about data. It covers so many areas which I'm not going to even try and go near during the course of this webinar. But it's really making you be very forensic and looking at all the different systems that you've got, and understanding the impact of a change that you're going to make. And you know, that can be quite far-reaching if you consider this isn't just a, you know, we're talking about data and privacy information. Things like a little folder on someone's PC which has got a load of CVs for some interviews they did about 3 years ago. That's personal information you've got no reason to hang on to that. It's out of date. So we're not just talking about databases, we're talking about people's personal information anywhere that might live. There are also quite, you know, as I say, everybody's trying to interpret these regulations and decide what they're going to do about it. We're all in that same boat. But we already get immediate questions we have here that we don't know the answers to. We work a lot on the site core platform, and that captures people's traffic and what they're doing in a thing called XDB, which is the customer experience database. So we have questions. Well, okay, at the moment when you come onto the site, we don't know who you are, but we kind of track you as an unknown user. But then when you become a known user, because I find out your name and your email address, when they ask me to delete them, I'm not sure I can do that. How can I do that? Do I need to delete them, or can I just anonymize them so I still get to keep their data and the sort of the analytics of the type of person that they were for my other reasons? But as long as their name isn't on it, is that then anonymized? I think that's the answer, but I don't know that for absolutely certain because it's untested. For example, it doesn't matter what platform you're on. If you're being asked to delete a customer, but you've got shopping baskets that they created going way back when, you can't just delete them as a user. That connect, you know, all those shopping baskets are linked to a user. So I can't delete them. I've just got to do something else with them that anonymizes them. I also might need to worry, well, okay, I can't entirely anonymize them, because if I'm a retailer who's just sold that abroad and I zero VAT'd, there was no VAT on that sale, I need to be able to show that it was an overseas shipment, etc. So how much of their address can I delete, or personal information can I delete if that was a request? So this is really important stuff. So, you know, things like customer lists to upload for email broadcasting. We as an agency get given lists of data by our clients to do campaigns or use for Google for retargeting campaigets. But we're as liable to be compliant as the person who gave it to us, because we're kind of part of that data controller journey, let alone the processor who, you know, the email broadcasting company that we're using. So yeah, there's you know, we're going to need maybe some sort of client sign off that we don't currently have in our system at the moment to make sure that we're not doing something wrong. There are so many things I probably didn't discuss today, but some other things. So things that really sit around the edge of this. Obviously, security is obviously built into a lot of this, but and really dwelled on all the sort of security that's absolutely necessary. If you're already a company that considers security seriously, then it shouldn't be a big issue. Then when you start looking at hosting, so where your servers live, etc., then things like cloud hosting and AWS and Azure and Google, there's elements in GDPR talk about, well, where is it okay to have your data residing, even though this affects EU citizens. It's not acceptable to have your servers in certain parts of South America, for example. So if you've got your sites hosted with AWS and Azure, etc., then where exactly is it? Well, it's not in one place because it's cloud hosted, but where isn't it? Can I have a version of AWS? And you can buy AWS and Azure in this manner. You can say, well, okay, I want a cloud hosting solution, but I only want my data to live in these parts of the world. So that's an interesting subject in itself. We're actually planning to do an event with Rackspace on that kind of subject later in the year. So if you've signed up for this, you'll find out about that. I've briefly mentioned before personnel files. You know, like I say, folders of people's CVs sitting on a hard drive somewhere is personal information. So don't think that you know, it has to be in an actual database. Things like phone call recording, etc. This is not explicitly well, I'm not really discussing it in this webinar, but if we're going to start recording any kind of activity and engagement with a person, etc., then it probably comes into this as well. In terms of reviews on a website, your sort of FIFO review type thing, well, if someone has left a testimonial, for example, and even if you've slightly anonymized it on your site because you like the testimonial, they've said you were great, Mrs. So-and-so. If they've asked you to delete that, you've then got to go, well, actually, did that person leave a testimonial that we're using elsewhere? And then if it was their testimonial, can I keep that testimonial without attributing it to a person? Or actually, by being requested to delete their personal information, was the testimonial their personal information? Is that part of that? Don't know. I've got my own views, but it's a question that we're raising. And then I touched on it briefly. Data portability, this idea that somebody can take the data, not only ask you to delete it, but allow them to have a copy of that data in a format that, I think their wording is, as easy as possible to use. I mean, it was really kind of invented so that in theory you could ask Facebook for all the data you've got about them, and you could go and give that to another social channel, for example, so you don't stay with them because it's only them that's got that data. But really the wording is broad enough, it now applies to all sorts of things. So that could be a challenge for you as well. And part of that challenge is not only the work that might be involved in doing it, but the possibility that you might not even be able to make that change if you're using systems that you didn't build, or you don't have the ability to change, and the vendor you're buying it from isn't going to change. Then that does create a problem for you. So I've taken up quite a lot of time. I'm just going to talk about quickly now, well, where you are now, what should you be doing? What, because that's what most of you maybe want to know. What should you be doing right now? So you need to be thinking, well, actually, what data can we remove already? What should we just delete? What should we chuck out? We've got probably stuff sitting there that we keep because we had it and we thought it might come in useful at some point later. Well, now's the time to have a clean out, because the more data that you've got, the more things that are at risk. You need to be looking at your databases and going, well, actually, do I need all that data, but do I need all those fields? Is there bits of data I capture about people that I only need at a certain point in my relationship with them, which I don't need anymore? So something I might ask for them pre-sale, or when I'm still providing them the service, I might need to keep that when I'm working with them. But if I'm no longer working with them anymore, then maybe I don't need that information anymore. So that sort of thing. The next thing would be picking your data protection officer. So one of the things in the GDPR is about somebody owning this. Somebody who's a representative in your company, firstly to sort of police it and oversee it, but also be the person who can, takes ownership of things like breach notification. So in certain organizations, that may be a big enough job that's a new position. That may be a big enough job that actually you could outsource it because you don't really have the skills in-house to do it. But somewhere or another, somebody needs to be owning this. As well as that person, quite frankly, you need a team of people. There's so many things. I'll talk about it a bit more on the next slide, but this isn't really a person. This is so far-reaching. There's a lot of people in both at a C-level of the company and around the team that need to know about this. There's probably tools that you need to get to be able to do this. You probably haven't got either the facilities built into the software and the databases that you're using, or you might need to buy some new stuff that you haven't got. Things like penetration testing. I mean, you might be buying software or have websites built on platforms that are recognized, but have you really tested to see if they're hackable? Even if that software in its own right is not hackable, the way you combined it with another piece of software means it might be now. So not the sort of thing people have gone out of their way to do, but given the responsibility that you have, something that would be urging people to do. And as I said earlier, you need to prepare for a breach response, have a sort of bit of a game plan in place, and got the tools that you need to be able to detect what happened, who did it, what did they see, what have they done with it, that sort of thing. So again, can't sugarcoat it anymore. There are no real shortcuts to this. It'd be nice to go, oh, well, to be GDPR compliant, you just do X, Y, and Z, and then you'll be fine. Obviously, businesses are in the business of taking calculated risks. and there are certain things you could perhaps not do, and it never bites you on the bum, but you never know. So we wouldn't obviously advise that. The problem is, as I said, the team needs, it's an IT issue, it's a technical issue. You need people who understand what you're doing with your marketing. They need to understand your marketing systems, what's going on with that data, and what third-party bits of software they might be using to do it. You need people who understand the whole sort of business strategy, where you are now, where you're going, what the costs might be, and ultimately you need some legal expertise. Everything I've told you today is my interpretation of GDPR. I'm no lawyer. I can't be held responsible for saying, well, I think if you do this on the page, you never have any trouble. Nobody can sue you. At the moment, I'm just telling you my interpretation of the data privacy regulation. That's what lawyers are for, if you like, really, for them to reassure you that, and make sure your insurance company's happy. It's not just you either. It is all your suppliers. So that's a huge thing. Anybody who provides you with a service, or people you work with and share data with, etc., you need to be happy that they're compliant. So therefore, they need to have explained that to you. It might be stuff that needs to be in a contract, for example, because it probably isn't there right now. So probably all contracts that we all have with each other is a little bit out of date and needs reviewing. Other things you need to do is get everybody on board with this. I'm trying to enthuse you about why this is important, but throughout the whole company, more people need to understand the importance of this and how this is a bit of a mindset change. Obviously, the obvious things around policies on websites. So, you pretty much guarantee every T's and C's and privacy statement on any website in the land is slightly out of date. So there's a bit of an obvious one, and then obviously any forms and consent forms and any sort of data capture is going to need to be updated. So those are no-brainers, all of those things there. But the last one is most critical, as I said. Even if you do all of that and you start behaving in a place that's compliant, you probably still at one point will need some legal advice, because if you rewrite your forms and your privacy statements, etc., you're taking a huge risk, possibly without getting somebody who really, really legally understands the regulations involved. One of the things that we're doing, I'm just going to talk about quickly, is a gap analysis workshop with a partner of ours, Duncan from iComply. They specialise in this sort of thing. He actually does GDPR training courses for the Chartered Institute of Marketing and Institute of Digital Marketing, IDM. And it may be something that will interest a number of you on the call, and please, talk to us afterwards about it. He's actually, as you can appreciate, you cannot fix this in a one-day workshop. I cannot tell you everything you need to know in this webinar. There's so much that will be unique to you. So what he's come up with as a product really is a kind of one-day workshop, which is kind of tailored to your organization based on the sort of thing that you do. It's basically going to introduce the core concepts and principles of the GDPR, and then kind of look at maybe your processes and current data flow, and then highlight where the issues might be, kind of looking at your current privacy policies and data capture notices, and then signposting what you should do about it. Now, this is only in a day. Well, it's called a day workshop. There's a bit of stuff happening before and afterwards, but essentially on site with a day. And the idea is to get a bunch of key stakeholders involved, be it from marketing or operations or the C-level of the business, to really go through this stuff. There will inevitably be an output of this, which means you need to go off and do certain stuff, some of which you can do yourself, some of it you need to take advice on, further consultancy, or get a lawyer involved. But that's one of the sort of things that might be a sensible step for several of you. He's doing that stuff for about £2,500 plus VAT, but it's the advice I'm giving to our clients who want to know more. You may have existing providers who can help you with this, but we've worked with Duncan for a while now, and I really know his stuff. I know he knows his stuff, sorry. So that really brings me to the end of Oh, have I been on for an hour? Wow, it's funny how time flies. Hopefully you're all still there. But have we got any questions, Sarah?
Yes, we do have some questions. Just initially, I've had a few people email me. I've had a few people email me about what they will the presentation be shared post event. So yes, the recording of today's presentation and all the slides will be shared with everybody post event. We've had a question in from Maria, and they've asked, is there a difference between how B2B brands should treat GDPR compared to B2C brands?
As far as I'm concerned, no, because it's not really about the brand, it's about people. So even if you are a person working at a company, you still have the same rights. This isn't like previous laws where we were meant to, we could email people, or if they were B2B, because we had a business relationship with them, whereas a B2C we don't. So no, their rights are no different, because it's about their rights as a person.
Okay. And you briefly touched on this. Another question has come in. How can we delete somebody's personal data from every system that we have within our business if they are a customer and we need to transact with them?
Well, that's where I think the information isn't ambiguous. If you need to transaction with them, then that's a legitimate interest. So you cannot delete their details. It would be a bizarre thing for them to ask you to do if they want to continue to be a customer, I suppose. Yeah. If you did delete them, then that would be very inefficient. And then how do you delete them that then they want to at a later date become a customer again, and you're saying, well, okay, you don't exist in our records, so therefore we're going to treat you like a new person. But if it's sort of contradicting. It's rather contradictory.
Okay, and another question here, what sort of things should we be doing now in our development or digital marketing projects to ensure that we are GDPR compliant for the future?
Well, I mentioned the data privacy impact assessment. That's something that we're bringing into all projects that we're working on now. Anything that's requiring anything to do with data capture or processing of personal information, we're having to say, okay, let's take a fresh look at that. We used to just create a form and ask people these questions. Now we have to go through a bit of a process and say, okay, well, we've asked those questions. What are we going to do with that data? Where's that data going to end up? And is there anything about that process that's going to mean we're no longer complying? So it's not just existing stuff, it's new stuff as well. It'd be wrong to be building something right now that isn't compliant. Be a very inefficient way of going about it anyway.
Yeah, okay. And thinking about not necessarily the data that we're collecting from today and in the future, but kind of existing databases or lists of people that we have, and how do we manage that data and make this GDPR compliant? Would we contact those people in those lists and ask them those specific questions?
So my interpretation is, if the way you captured it originally was kind of fine, you haven't changed what you're doing from what they signed up for in the first place, then I don't think you're not obliged to do it. But if you're doing it in any different way, then I think it's a bit of a no-brainer. I think, yes, you should be putting some sort of communication, encouraging them to re-give their consent in the way that you want to unbundle it now. So I think that is kind of clear. There's some sort of people are saying, oh no, any data you've got now is rubbish and you can't use it anymore. But I think if, as per perhaps one of the previous questions, if you've got a load of customer data where these are people you have an ongoing relationship, they're a customer, you're already transacting with them, asking to keep their data is a bit ridiculous, really. But asking how they would like to be communicated with and the type of communications you're going to interact with them is probably sensible. And of course, even if they opted into that sort of stuff, they didn't necessarily agree that when they went to your website, they were happy to have that experience personalized based on what you know about them. So again, you've got to ask them that question additionally.
Okay. We've got quite a few questions here, so I'm just going to whiz through the next ones. What are the implications for us as processors of our clients' data? Is it up to our client to set the policy of how we process their data?
So just checking they've got the right wording there. So a processor in the GDPR sense is somebody who might be running the software or creates the software to process the data. The person who's doing it is the controller. It's their data and they're controlling it. So I'll see if I can answer that question. So I answer it either way. The law, my interpretation of the regulation is you are both responsible or liable from the regulation point of view. Of course, if you are the processor and it's just your software, and then whoever's using it, who's now considered the controller, has done something stupid or used it in a way that they weren't meant to use it, ultimately it will be them who will really be held responsible. But the law is really saying you both are, which is kind of a change, I believe. So it is something that both sides need to worry about, and both need to be happy with the processes that each other are doing.
And do you think there'll be any more information forthcoming on profiling and automated decision making? As that sounds quite vague at the moment.
I'd agree with that. It is kind of vague at the moment, and that's why I was slightly vague. We are trying to learn ourselves. I mean, anything you'll find on any of these GDPR workshops, any of the consultants who come in and advise you, and even lawyers to a certain extent, they're all interpreting the regulation. We are probably at the point where we're doing more of our own forensic work to try and work out what we think is right, and we'll take advice on that. But equally, I think it is going to be down to people like the ICO to offer guidance on it, really. I don't see anybody from EU updating the GDPR to make it clearer. It's going to have to come from the lawyers before we can do something that we're certain on.
Okay, and our last question, can you recommend any email marketing systems that allow unbundled consent so that people can agree for some types of communication but not others? Or is this down to how you build your own email communications?
Yeah, I think it's more like what you just suggested, really. I've not really come across an email broadcast system, for example, that is or isn't compliant, really. Most of them give you the ability to ask what they want to opt into or out of. What possibly isn't in a number of them yet is okay, so they can come on, they can sign up for things in a very granular way, but what tools are you going to give them to be able to unsubscribe from that in an ungranular way, and what systems are in there for you to be able to clearly explain that by them unticking or ticking what the results of that are going to be. So I think, I don't know all of the different email broadcast systems in a great deal of detail to really properly answer that question, but there isn't one where I can say, oh yeah, these guys have got it, but most of them have got the flexibility to do it, I think.
Okay. Well, I don't have any more questions, but thank you to everybody that have asked questions. Lots of people asking that they maybe missed the beginning of the webinar. Can I send the slides on? So yes, we will do that after the event. That will probably be tomorrow. And if nobody else has any more questions, I'm going to say thank you to Paul for providing a great webinar with some great content, and we'll catch up with you all soon. So thank you for attending.
Thank you. I hope you enjoyed it.
Thanks a lot. Bye.
Bye.